Welcome to the Exhibit A podcast.
Hello and welcome to Exhibit A. Today we're going to talk about a very important topic, and that is what in the world is going on in the Los Angeles court system. In light of the stay-at-home orders and the fact that the court is virtually closed, what's happening to all those family law cases that have been pending? Fortunately, I have a panel of experts with me. And to start off, let me introduce them to you. First of all, we have Casey, my partner. How are you, Casey?
Hi, Don. How are you?
Good, good, good. Not bad, I guess. This is the day after Easter. Feeling a little bit full, but I'm okay. We also have Anthony. Anthony, how are you?
Good morning, Don. How are you? Good afternoon, I should say.
Yeah. It's with the weather out here, you don't know if it's morning, night, or what. It's been such
Exactly.
And then finally, we've got Monet. Monet, you were in court recently. We're going to talk to you about that. How are you doing today?
Hi, Don. I'm doing well. Thank you. Hanging in there and going into week 3, almost week 4 of working from home.
You mean home confinement. So first of all, I should ask, do all 3 of you have your ankle bracelets on right now?
I think it's strapped to me, so I don't think I'm allowed to take it off.
Okay. So it seems to me, Casey, that the court system here in Los Angeles is doing its very best to cope with the situation, but we family law practitioners are hearing almost on a weekly basis something that's being changed. And in fact, the week prior has been completely reorganized and there's new messages. And just last night on Easter Sunday at about 5 p.m., you received a message from the LA Bar Association concerning Judge Riff's email, and he's the supervising judge over in the Central Courthouse. So why don't you tell us, in summary, what Judge Riff had to say?
Right, Don. So there's a lot of communication coming in, and it's coming in evenings, weekends. It's coming in almost daily. Things are changing, and we are all at the edge of our seats trying to figure out exactly what's happening with the court system. We anticipated, the court was supposed to open next week in April, and we just learned that the court closures have been extended to May 29th, which that's, kind of a big deal for us practitioners and for our clients. That's the official extension date. However, the presiding judge was very honest in saying that it's anticipated that closure is going to go through June 22nd, which comes to a big surprise to us. But luckily, we're already in talks with everyone from our firm and figuring out what our action plan, and we all have to reinvent ourselves because we're figuring out how to move forward with what we have.
Yeah, and so the court was real honest with us and said that those new dates that they gave us like a week or 2 ago, they're not really new dates. They're most likely going to be pushed back. So Anthony, can you think of some of the more detail of the judge's email with regard to how they're going to handle cases from this point up until June 22nd?
Yeah, so as you know, Don, the court's been working on very limited operations in light of the coronavirus, doing their best to maximize social distancing, eliminate unnecessary hearing, continue matters that should be continued, and really limiting the matters the court hears to what's considered the essential functions. Now, previously, the court had defined essential functions as things pertaining to contempt regarding custody, certain types of custody, ex parte hearings, and other emergencies. But we're getting guidance from Judge Riff through an email that came in over the weekend. And as Casey pointed out, this information comes in at all hours, sometimes on the weekend, sometimes at 10 p.m. at night. So we're doing our best to try to keep ahead of the information and making sure that our clients are aware of the updates. So the most recent email that was provided by Judge Riff says that what was previously considered as an essential function, the contempt proceedings regarding custody, Judge Riff has opined and intended to indicate that those matters are no longer going to be considered essential. So if there are contempt proceedings involving custody, there's an expectation that those will be continued out past June 22nd. June 22nd is an important date. That's the court that Judge Brazil, Judge Taylor, and now Judge Riff is indicating is the intended date for the court to reopen by. That's not a date that's set in stone. That's just the date that they have penciled in as a goal to try to have their operations back up and running. But besides that, some of the things that he mentioned also was allowing the filing of ex parte papers by email. Mane and I recently appeared in court on ex parte matters. It looks like they're going to remove the requirement that a personal appearance is necessary. There's some discussion about including what's called WebEx. WebEx is a video conferencing software. That is a program that's supposed to be implemented for the purpose of restraining order hearings, which do get priority and do fall under the essential functions. And basically just kind of some general information as to the court's view on when operations are going to start ramping up and what other additional steps are taken to try to resolve some of the social distancing guidelines that have been passed down from the state and local government.
Dude, you sound like you wrote the memo.
I read it quite a few times because, again, we had an ex parte proceeding, and it looks like if we had that ex parte proceeding 1 week after the fact, we wouldn't have had to make an appearance in court. Again, as Casey said, this information is coming in hour by hour.
Okay. So, Mane, you were recently in court on a really was a domestic violence type of a case, and you had to go there to what, get a continuance?
Yes, Don, I had to go in and get my restraining order continued for my client because I didn't want the temporary restraining order to expire. So we were initially told that we could do it via telephone and we would just call the court. But as you all know, the clerks are not available via telephone as they were before. So we tried calling throughout the week and we were unable to reach anyone in the department. So I had to go in and I gave notice to the opposing side, and he wasn't happy about it because he was hoping to avoid having to go in person. So we went in last Monday, and we didn't even have to go into the department. You know, everybody was kind of standing outside and checking in. The clerk would come outside and get your paperwork, and if the judge needed to talk to you, he would call you in one at a time. Fortunately for us, we didn't have to go in and appear in front of the judge. All we had to do was give the continuance forms to the clerk, who went in and got the judge's signature and brought it back out. So it didn't take too long, but there was maybe a line of 20 people waiting outside the courtroom, trying to go in one by one to get the matters continued. And, you know, some people were trying to present the case that same day in front of the judge, and I could tell that they were trying to avoid, the court was trying to avoid this at all costs and trying to get everything continued.
You know what, this time in our lives, with this stay-at-home order and social distancing, walking around out there, you feel like you're in one of those movies, you know, after the War of the Worlds, man, and there's barely anybody left alive, and you're walking, you know, maybe the Planet of the Apes or something, you know. No offense, we're not calling anybody here apes or anything, but, you know, walking around out there, it's very bizarre. How did it feel, Mane, when you were in the courthouse and it didn't look like it normally does?
So my experience started right before I even got into the courthouse. There's usually a separate entrance that I go in from the side that, Dawn, you showed me. And you avoid the big line in the front, but that entrance was closed.
Wait. You're not supposed to tell the public that, man. That's our secret.
So I went in and I was trying to, there was a line, it wasn't too long, and there was tape on the floor marking, you know, where you were supposed to stand. And I went to the attorney line, and the security asked me to show him my bar card. So I got a little close to show the security my bar card, and the lady standing in front of me started yelling at me, saying, you know, to keep my distance. So I was like, okay. So I had a mask, I had gloves on. I checked in. You know, going through security was a little different than normally because they checked your case number prior to you even going through security, which is something they never do, to make sure that only essential people are appearing. So I was told what department will be covering my hearing. And the courthouse was empty, which is unusual for, it was almost 8:30, so it's usually very packed. The elevators were working fast, which was a blessing because they usually take 5 to 10 minutes for you to take the elevator. The benches were, there was signs up saying no more than one person can sit on the bench. Although as people got tired, they started ignoring this rule. I noticed people were sitting on the bench together. The clerks, were coming out and checking people in, but they were yelling across the hallway because some people were afraid to come closer to avoid being close to the crowd. There was a crew going around cleaning the benches, cleaning the escalators, and it was all very surreal, being there. And I took my mask off because it was hard to breathe. But, I noticed everybody was kind of on edge and standing very far from one another, which was good. I guess everybody was following the rules, but it was definitely different. And it made me a little nostalgic, and I missed the old days of the crowded hallways and, a lot of people. And it was definitely something I'll never forget.
So that was over at the Central Courthouse. I know, Casey, you recently went into the Pasadena Courthouse and had kind of a similar story. Was it any different than what Monet just described?
I think Monet touched upon kind of all of the basic points about the requirements. It really was surreal. I felt like I was in a movie or a TV show. I will say one of the things that's interesting is that you can really get creative. I have the clerk of the court sending me emails right now, which never happens. The clerk of the court in Pasadena is working with me and helping me push through paperwork that would otherwise require a court appearance. So I think it's helpful to have such a great relationship with the courts, the judges, the clerks, and also my team, my paralegal works one-on-one with those individuals. So I think it's a time where everyone's working together and cooperating. I think it's a time for everyone to get creative. And there are certain things that are happening that usually don't happen. I'm avoiding a court appearance tomorrow because everything was done via email today, which is super helpful. And I wanted to touch upon something I said earlier, and that is, we all have to reinvent ourselves. We're not in court, but the cases are still moving forward. We're able to file our cases, our dissolution of marriage cases. A month ago, none of us used Zoom technology. Now we use it almost on a daily basis. And we are taking depositions via Zoom. We are meeting for voluntary settlement conferences and mediations via Zoom. We're moving our business forward. We are reinventing ourselves with the technology. And when all of this is said and done, we are all going to be stronger because we are going to bring with us this technology and be more efficient and do things that we previously couldn't do outside of the office. So it's all about the silver linings. And that's what I want to convey to people watching this podcast.
Yeah, I agree. So Anthony, you talked a little while ago about what the court had stated it would be changed. I don't know if you mentioned this, but the court indicates that court call will be used more frequently. And then you said that there's this WebEx tool. And
Right.
If I understand this right, the court may be doing hearings via WebEx. Is that your understanding?
So it's kind of interesting because we are learning this process as the court is. The court has never had to deal with a situation in which family law appearances can be made by video conferencing. This has been something that's been done, I think, in other areas of law. I think civil does allow for appearances by video conferencing, and I believe WebEx is the platform that they've used in that department. We tend to get things a little bit slower than civil. They're still implementing e-filing. That's something that was supposed to be transferred over by civil, but they're still working on it. But the opinion of Judge Riff is that WebEx should be implemented at least for the certain matters. I think he mentioned having those be used for restraining order hearings in the same manner as they're using those in civil right now.
Yeah, I have seen the courts do video proceedings when people are in other countries. I haven't seen that in a long time, but I've actually seen that before. I
Okay.
always wondered why we don't do more of that anyways.
Right. Yeah. I mean, the court's not the first one usually ever to adopt new technology. It's a shame. I believe a silver lining that can come out of all of this is the court's recognition and application of new means of communication in more expeditiously resolving family law disputes. I think that's something that's a positive that will come out of all of it.
Well, before we talk about the positives, because I do agree with you that there, in Casey, that there's a silver lining to a lot of this. I want to go back to you, Casey. Do you think that there's anything that could be hurting our system of justice by doing all these things? I mean, we're talking about the possibility of having hearings, over court call or possibly video conferencing, people not being allowed to go in the courthouse to really be spectators, which has always been a part of the American experience in our courts. You can't go in there and watch cases anymore, apparently. So what do you think about that?
Well, I think that the courts are doing what they can do with what they have. Obviously, that cuts into a very important aspect of what we do, and that is cross-examination and really allowing the court to assess the credibility of a witness. That's a constitutional right, and really it's part of our job as lawyers to extract certain information or to reveal certain aspects of a witness's credibility. I mean, that's pretty essential to what we do. We lose that if we're examining a witness by way of phone. By video, it helps a little bit, but there are some issues with video that we've discussed in-house, and that is you can't really tell if a witness is being coached, for example, if they're receiving, signals from their attorney. Obviously that's unethical, but you can't really control that. And we've had, meetings, and we've talked about ways to get around that. But I think that's one of the problems. Another issue I think could be, like you mentioned, Don, the ability to sit. I often sit in a courtroom if I know I have a hearing coming up in front of that specific judge. I like to observe the judge's demeanor. I can't do that right now. I really don't want to, but that's one of the other issues that we have. We really can't go about attending certain proceedings like we used to. But again, I think the court's doing what it can. If we can get the video going, I think that would be helpful, like I said, for purposes of examining witnesses.
Yeah. So Monet, with regard to these changes, the delays, how's that going to impact our clients' cases?
Well, Don, Casey did mention, fortunately, that we still have the ability to file new applications, petitions for dissolution, which is great. I think the one good thing coming out of this is the fact that the court is now finally working on perfecting and applying the application to allow us to file electronically. And I know that's been in the works for the family courts for about 2 years now, and they just can't get that done. And so hopefully this is that little nudge that the court needs to get that program going. I think, aside from being able to file electronically, we've been fax filing, which is great. I do have a lot of restraining order hearings that are getting pushed back. And I think depending on what side you represent, that could be a good thing or a bad thing. I know that it's allowing some parties to settle things quicker than otherwise because of the fact that they have to wait such a long time to get into court. I think it's giving us all the opportunity to try to settle our cases and kind of really sit down and think about, what the case is all about and what we could do to settle, just because, we have to wait so long to get into court that people might be more willing to sit down and talk to one another. I think, emergency situations such as custody disputes and restraining orders, I think it might be affecting those types of cases negatively, but I think otherwise, we're really adopting really well and trying to think of creative solutions, whether that means doing depositions via Zoom or settlement conferences via Zoom. And I think, I don't know about other firms, but I know that our firm is really has adopted already quite well to using technology and it really hasn't stopped our cases from moving forward. You know, we're working with new clients, we're completing things on time. And I think coming out of this, really, I don't think our cases are going to be hurt or delayed for whatever reason, because I think we have adopted really well to this situation.
Yeah, and you know, you just mentioned something that's really true. Is we've already done a deposition. Tomorrow I've got via Zoom, believe it or not, and tomorrow I have a settlement conference. We're going to be participating in mediation, things of that nature. So, Anthony, with regard to this alternative things that we can do, do you think that we could do some private judge trials and maybe even discovery referees if people aren't behaving? Do you think that would work?
I mean, I don't really see any reason why you wouldn't be able to continue seeking out alternative means of case resolution through voluntary settlement conferences, private arbitration, mediations. I mean, mediations, I think, I've always been of the position that mediation is a very undervalued resource for resolution of especially contentious family law cases. If you have two parties that are willing to explore that option, you would ultimately save a lot in cost. The idea that we're able to tap these resources that are still available and still efficient means of designing a divorce case or a custody matter. If you're able to settle it through that means, then there's no need to appear in a courthouse that is now subject to very, very limited and restrictive policies, social distancing, a limit on the types of cases that can be heard. There's a lot of options out there if people are willing to seek them out in terms of resolving cases, especially now that a lot of these hearings are getting continued out into the future. It definitely changes the landscape of a lot of cases. It's going to affect issues like custody and support. If you're not going to be able to get in front of a judge until, well into summer, that might drive or be the impetus to try to settle some cases. And we always encourage matters to settle when they can.
Yeah. You mentioned one, or you didn't mention one advantage, and that is you don't have to get on the road in those crazy California freeways and drive to court anymore. You could just do that. Wouldn't that be nice, Casey, if we could continue doing this even after the court's open? You won't have to drive to the west side for mediation. You don't have to fight that 110 freeway to get downtown.
Right.
Well, I think there's something about that in person that is invaluable. That's just my personal opinion. Maybe I'm a little bit old school. That doesn't mean that there are some things that can't happen via Zoom. And certainly now that we're all kind of in this space, I think that's what we're all working with. So when that opportunity comes for me, I'm going to act as if we're all in the same room and make just the same effort to try to settle the matter, just as I would if I did drive to downtown or the west side for a mediation.
So you didn't go to 3 years of law school and take that horrendous exam in order to practice by Zoom. Is that what you're telling me?
That's what I'm telling you, Don.
Okay. Well, good. I think I'm with you on that. So let's, Mane, I want to talk to you about the contempt. Anthony already said that the court said that that's not a essential hearing. I don't know if that's the right word, but contempt is going to be treated kind of like something that's not an emergency. Do you think that people are more likely to violate court orders now, in cases where they're being kicked down the road? It's like, hey, I've got nothing to lose because nobody's going to hold me to it. What do you think is going to happen there?
I think that's a great point, Don. I actually was thinking about that this morning as I was doing a motion for one of my cases where I represent the spouse that's unemployed and needs support immediately. And the other person is refusing to provide any support. We have extended an offer informally until we're able to get into court. And, we haven't heard back, which is not surprising. And I think even after I filed this motion, I know that the hearing's not going to be scheduled until July or August or September. And I am a little scared about the consequence of that and the fact that the other person might just, especially in this case, since there is no order, I think, they have nothing to gain from paying support earlier than they have to. And I think for those cases where there are support orders, I think the fact that so many people are unemployed and so many businesses are suffering, I think that's going to be a convenient excuse for people to use to avoid paying support, even if they do have the means to comply with an order. And I think, you know, in terms of custody, I know there's been a lot of conversation with the judges and attorneys, and there's a lot of forums to try to help us determine, you know, whether and to what extent we should be following custody orders and how we should be advising our clients. And I think, you know our office has advised the clients to comply with the custody orders to the best extent possible. But I know that a lot of people, especially people who are not represented by attorneys and who don't know any better, might, try to avoid sharing custody, or might just use the virus again as a convenient excuse to, miss certain things, or not follow certain orders because, they can't get into court on time. And even when we are in court months down the line, I mean, how likely is a judge to hold you in contempt, given what we all just went through? So I definitely think that this can have a downside for people who want to use it as an excuse.
Yeah. Anthony, what about the situation where people want modifications of custody or want new custody orders, and now there's this status quo that's artificial because it's being built in, and somebody is, gatekeeping and saying, hey, look, I've been the primary caretaker for 8 months. Why should things change?
Yeah, so as you know, Don, and one of the things that we factor in part of our argument in modifying custody orders is that status quo is merely one of many factors that the court considers. And I think that the way the court is going to look at status quo is going to be in the grander context of what happened during this coronavirus. I feel that the court has a very long and very accurate memory, in the sense that if there's been non-compliance with orders, or if there's been evidence to show that someone's used this situation to their advantage, or to try to withhold custody or things like that, that's something that the court's got to also take into consideration, regardless of whether there has been a status quo that's been established or not. So yes, there might be a change to custody arrangements. As of right now, we've gone through that topic, I think, in detail. But one of the things that we haven't talked about is, what ultimately is the court going to do when it comes time, when the day of reckoning comes, I guess you could say, and one person hasn't obliged by the custody order. How is that going to be something that the court considers? And I think that's something that the court may not look kindly upon. We can't get in front of the court right now for contempt proceedings, but it doesn't mean that the orders are, completely go out the window. There's still an obligation there to comply to the best extent possible. And where that's feasible, I think the expectation is that the clients and the parties should endeavor to try to do that.
Yeah, I really like how you say there's going to be a day of reckoning out there.
Right.
So remember,
Exactly.
You will be in front of a judge eventually. Casey, what about the situation where people want a modification of support, right? I can't pay that child support. I can't pay spousal support because I lost my job, and now you're going to make me wait 8 months before I could get a modification of the order. What do you have to say to that poor person?
Okay, well, I'll keep it brief. I'll make 2 points. The first point is that you need to file your motion for modification, because there's the concept of retroactivity. So if I file my motion today, even if I don't go to court for 3 months, the court has the discretion, and in most cases will order retroactivity, meaning that the court's going to order support as of the date that you filed your request for modification. And that means that it could be 2 or 3 months worth of either an additional amount of support, or you may have overpaid a certain amount of support. So number one is file your motion for modification so you can get the clock running on retroactivity. And my second point is that if you truly have the inability to pay, then you might have a defense to a contempt of court action. No one can violate a court order, right? You're not supposed to do that. But if you lost your job and you do not have the money to comply with that court order, then you now have a defense if somebody prosecutes you for contempt of court. Now, don't pay your Porsche payment and your country club payment first, and then say that you don't have the ability to pay, because then you're going to lose. Your child support and complying with court orders, that's going to come first before you pay those other things.
Good information. So, well, I think we've really talked a lot about this, and unfortunately, we're running out of time. So let me just go around the horn one more time. Mane, what are you going to tell your clients in this interim period? What good advice can you give them?
The one thing that I've been constantly telling them is that we're here for them, if they need us, and to keep following court orders. And because as Anthony said, you're eventually going to be in front of a judge and you don't want to be on the wrong side of that dispute. And that this is just temporary and things will go back to normal. And, how we act and how we behave in times of crisis like this really defines who we are and shapes our cases and our character as well. So just keep doing the right thing, and I think we'll come out okay.
I agree. Anthony?
I've always been of the opinion and that court shouldn't be the first thing that you go to. It's always a last resort, and that's still my opinion right now. The inaccessibility of court really does kind of hone in on the fact that we should use this time in a way to try to investigate settlement of these cases, mutually agreeable terms, things like custody, things like division of assets, things like that, and not rely on the court so much because, of the fact that it's operating on a very limited basis. But not only that is that it's extremely expensive for litigants, normal day-to-day people to afford counsel to go in and argue a case and have to sit there for 6 hours and be billed for that time. This is really an opportunity to try economical and efficient resolution of these types of cases through non-judicial means, through stipulations, through things like mediation or arbitration. There's a lot of ways that you can resolve a case without having to go in front of a judge. And most cases do resolve that way. And that's ultimately what's the most cost-effective way of getting these family law cases taken care of. So what I'll be telling my clients is, hey, let's go back to the drawing board. Let's see what options are available. Let's see if they'll be willing to settle on these terms. And if not, and we're not able to do it, we'll still always have the opportunity to go back to court. Granted, it won't be on the timeline that we'd like, but we have some time to try to explore something new right now.
Good. Casey, you got the last word, partner.
Well, I would say that, although there are many things that are different, at the same time, the cases are going forward. We're moving forward. We're moving the cases as best as we can. And certainly there is a certain leverage that comes with the ability to file a motion and get something resolved. We don't have that right now, 100% of it, although we can file some things. But each and every one of us as practitioners, we all have negotiation skills. Now's the time to really flex those skills. Pick up the phone and call your opposing counsel and get the case settled. Most divorce cases don't go to trial. If you cannot settle your case right now during these next month or two, then you can prep it for trial. There's nothing stopping us from doing that. So my takeaway, and what I'm telling my clients, is your case is moving forward with or without this situation.
Excellent. Well, the three of you just brought a tear to my eye. That was wonderful. We got such outstanding people in this office. Unbelievable. Thank you very much. And thank you for joining us on Exhibit A, and we'll see you next time.
For more information, visit us at PasadenaLawOffice.com.